Hi friends, this is Coach Ranchod, immigration attorney representing clients throughout the 50 states. Welcome to our weekly immigration show. Today we're talking about the Affidavit of Support and 3 myths surrounding that Affidavit of Support that you'll need to know because you want to have this information when applying and utilizing the Affidavit of Support with certain types of immigration applications. But if you haven't already, smash that like button, like boom, because that helps with the YouTube algorithm so people like yourself can stay informed and learn more. Thank you so much. So let's get started. Okay. First of all, let's talk about what is the Affidavit of Support. So the Affidavit of Support, I'm going to put this in the context of filing for a marriage-based application, specifically adjustment of status within the United States. You're applying for a green card, you're the US citizen and spouse, you're filing for your spouse, and part of that application that's required is the Affidavit of Support. The Affidavit of Support is typically the person who is filing, the petitioner can also be the sponsor for the Affidavit of Support. However, the petitioner doesn't necessarily have to also be the sponsor. We're going to dive into that in further detail. So, what is the Affidavit of Support? Well, you're basically, by signing the Affidavit of Support, it's a legal contract with the government. You're basically stating you're going to take financial responsibility if the person that you're sponsoring takes benefits. Something really important to note is that this obligation does not end even through divorce. It does end if the person you're sponsoring becomes a US citizen or has 40 qualifying quarters of work, which is usually equivalent to 10 years. So it's something to take very seriously when deciding whether or not you want to be a sponsor for the Affidavit of Support. Let's talk about those myths that I was talking about. Myth number 1. If I have a job, I meet the Affidavit of Support requirements. Wrong. That's not accurate. In order to qualify for the Affidavit of Support, you need to be able to make 125% above the poverty guidelines in order to qualify. And this also depends upon your household size. So you might be wondering, well, how do I know that? Well, USCIS.gov, there's a form called I864P. You can look that up there. Now, important to note, it's not 100%, it's 125% above the poverty guidelines. So you might be wondering, okay, that's cool, but what does that look like? Well, for household size of 2, currently right now, that is 22,887. And for a household size of 3, 28,787. The bigger the household size, the more money you have to make. Myth number 2, I don't have a job, so I can't file that marriage-based application or family-based application because I don't have a job. Wrong. There are loopholes to this requirement of being the primary sponsor for the Affidavit of Support. So let's talk about some workarounds if you're not employed, or if your income is below the poverty guidelines. You can get a joint sponsor. The joint sponsor needs to, of course, be 125% above the poverty guidelines, as I discussed earlier. Second, they also need to be a US citizen or permanent resident. You might also be in a situation where you are unemployed, but you have significant assets. So you might be able to also qualify based off of your assets. This is much more involved than just qualifying based off of income. You have to actually demonstrate that you have the value of your assets, and it gets a little bit tricky if you're doing that based off of your house, because you have to look at what the mortgage is, you have to look at how much equity you have. If you have cash assets, it's a little bit easier than, for instance, looking at properties such as a house. But it is possible to qualify based off of assets if you have the required assets. Otherwise, look at having a joint sponsor. Which leads us to myth number 3. My joint sponsor must be a relative. This is a little bit of a tricky one because you don't have to have a relative. I have seen the Department of State and USCIS question at times, and this was more prevalent during the Trump administration, about why your joint sponsor is sponsoring you or why you don't have a relative sponsoring you rather than a non-relative. Now, I said only 3 myths, but I have one more myth to share with you, and that's one, I can't file because I'm self-employed. So that's another myth, because you can file if you meet the poverty guidelines. The issue with self-employed individuals, a lot of times they may not have the income necessary to meet the poverty guidelines, and I think that's where that myth has come from. So if you are self-employed, if you filed taxes last year, you can still meet the Affidavit of Support requirements as long as you're meeting the necessary income or you qualify under assets. I want to go back to one of the myths where you have that joint sponsor. So if you have a joint sponsor, you don't qualify because your income's below the poverty guidelines, you still need to have filed taxes for the last year. So that's another misconception that I see as well. Let's put it this way. You need to file taxes if you are required to file taxes by law. So if you are required to file taxes, you can't evade that responsibility. You must file taxes, despite whether or not you have a joint sponsor. And boom, that's it. We just conquered 3 myths, not 3 myths, actually 4. I hope this video served you. Post your comments below, share it with your friends, because your friends may not be talking about the problems that they're having with immigration, but they might find it helpful to know about this topic, especially because the Affidavit of Support is one of the trickier forms out there. And I want to acknowledge you for taking time to watch this video. By bettering yourself, you're truly amazing. And by bettering yourself, you're bettering your family. And by bettering your family, you're bettering our country. Thank you, and bye for now. See you next week.